in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome, everybody. Welcome. It is Tuesday, which means it's cases being heard before the Honorable Judge J. Cedric Simpson. So let's get started with this, and I hope that you find this stuff informational, that you're learning something from this. So let me put this. So this is from the last time. This is from last time.
Court does call the case, People versus Jason Heron.
Assistant Public Defender Ashley Bashir on behalf of Mr. Heron.
Oh, wow. Really? You didn't have to do all that other stuff. You wouldn't even come before me before. I know. What? Okay, what are we doing?
We are going to waive exam in both cases.
All right. Sir, is that a correct statement?
Yes, sir.
You're waiving your right to have a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have the hearing in either case and that you'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count one in both cases. Until your turn. You acknowledge receipt of the information?
Yes.
You waive their reading?
Yes.
And line stands mute.
Yes, we stand.
Defendant having waived formal reading, standing mute. Both cases, court will enter a not guilty plea. Pretrial in these matters will be set for January 30th, 2025, 1:30 before Judge Sly.
Judge, I'll give you the notice. when we leave. Yes, yeah, come on.
Bond will continue. Two. Court does call the case of the People versus Kristen Lucas.
Good morning, Your Honor. Hannah Mack on behalf of Ms. Lucas. To my right, say your name.
All right, what are we doing?
Your Honor, at this time, we would like to waive this matter to circuit court.
Pardon?
We'd like to waive preliminary examination.
All right. Is that correct, Ms. Lucas? Yeah. All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and it committed it.
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
We acknowledge receipt of information, waive formal reading.
Defendant
client was
waive
mute.
formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for January 30th, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond will continue. Thank you.
Yeah.
All right, you guys gotta clear out of there, yeah. Court does call the case of the People versus Ernesto Zuniga Alvarez.
Ashley Lonnie for the people.
Assistant Public Defender Ashley Bashir on behalf of Mr. Zuniga Alvarez.
Your name?
Ernesto Zuniga Alvarez.
All right.
Some of my kids are top of their class, and I fully attribute IXL to helping them reach that goal because of
Briefly, yes. Court calls the case, People versus Jamison Mitchell. When they get a chance.
Portia, Assistant Public Defender on behalf of Mr. Mitchell. Mr. Mitchell, petition at the record.
Jamison Mitchell.
Thank you, Your Honor. I did meet with my client. He's asking for a preliminary examination. I believe all discovery is complete.
On both cases?
That's my understanding, Judge.
All discovery is complete on both?
That's my understanding. Yes, Judge.
Okay. People have their witnesses available the 21st?
Yes, Your Honor.
Preliminary examination in person, January 21st, 2024. 9 a.m., that is before me on both cases. Bond will continue.
Couple days. All right. Thank you, Judge.
Thank you. Court does call the case of the People versus Kyrus Pinder.
Ashley Lonnie.
Anna Mackey on behalf of Mr. Kinder was appointed to my right. Please state your name for the record.
Sheriff Spender. Thank you. He's waiving exam. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Your Honor, we acknowledge receipt of information, waive formal reading, and my client will stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
January 21st at 1:30 before Judge Lundy.
January 21st, 2025, 1:30, Judge Kunk.
Thank you, Your Honor.
Bond continued. Thank you. Ready? Court does call the case, People versus Melvin Reeves.
Stephanie Cannon on behalf of Mr. Reeves, who's appearing to my right. Mr. Reeves, can you please state your name for the record?
Melvin Tyrone.
Thank you, sir. What are we doing?
Your Honor, this is an adjourned PCC. My client is asking for a preliminary exam in this matter.
All discovery is complete.
Your Honor,
Provided this morning.
Pardon?
The last of it was provided this morning.
Got it.
yes, we had conversations. The jail calls is what I was waiting on, and it's my understanding those have been provided to me, Your Honor. So we're asking for a preliminary exam. Your Honor, my client would also like to address bond when appropriate.
People have their witnesses available the 21st.
We'll do our best.
Preliminary examination, January 21st, 2025, 9 a.m. before Judge Moore as to bond.
Your Honor, my client is asking to be released on a PR bond, and if not a PR bond, he can be tethered to his home. Your Honor, my client, the victim has actually written and given different explanations as to what happened that day. My client has always maintained his innocence. He does not have to have contact with the complaining witness, does not want to have contact with the complaining witness. He is asking to be released. Your Honor, at the very minimum, if that is not what the court is inclined to do, he is asking to get his phone privileges back.
Your Honor, this is the case where we requested $250,000 cash or surety bond was set at $50,000, no 10%. The defendant, when this occurred, was in bench warrant status for a 2023 DV case with the same victim. I do think it's important to note that the reason he was waiting for jail calls is because he was contacting the victim while he was in custody. While I have not had an opportunity to listen to that, he had made 23 calls to the victim from when he was taken back into custody, which occurred, I believe, November 28th, between November 28th and December 19th is when those 23 calls occurred. So frankly, I'm concerned that anything the victim might be representing could have been influenced by her conversations with the defendant. Additionally, it's my understanding he has a bond denied hold from Allen PD. I'm not sure exactly what happened with the 14B case or what his bond is there, but presumably there would still be some implications. When we were here last, he, I believe, was held on a $10,000 cash or surety because he had been in bench warrant status and not being done this case. This is a home invasion first, but it's also a DV third with a tag along investigation. In addition to all of that, this is something where the defendant appeared at the victim's home unannounced. The victim opened the door and found the defendant, and the defendant then pushed his way into her home and began assaulting her. The defendant then stole the victim's house keys. I'm concerned by the totality of the circumstances here. We asked for more and only got $50,000 with no 10% privilege. I don't think any further reduction is appropriate.
Motion for bond reductions denied. Bond will continue. Thank you. Court calls case People versus Robin Robinson.
Pass along to people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Robinson, who's approaching now. Robinson, please. Record.
Yes, Robin Robinson.
Thank you. Your Honor, we are waiting on some discovery. I believe that was sent over yesterday, so we did not to review the video.
Probable cause conference, January 23rd, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
What's up?
Court calls case People versus Brandon Smith.
Pass along to people.
No.
Sorry. I was gonna say it's been a long day, but we're just starting. Mr. Smith, could you state your name for the record, please?
Brandon David Smith.
Judge, we're just asking for an adjournment in this matter.
Probable cause conference will be adjourned January 23rd, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
That's good. Court calls the case People versus Antoine Taylor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Taylor. Will you state your name for the record?
Antoine Taylor.
This is
All right, I have before me a plea form. Is that what we're doing?
just signing. And date. Yes, Your Honor.
Indicates that the defendant will be pleading no contest to the charge of assault and/or assault and battery 93-day offense. Upon plea to that charge, count one would be dismissed. That is the court's full understanding.
That is correct. Thank you.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Antoine Taylor.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and/or assault and battery. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yeah.
Okay. Two things about it I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yeah.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes. You
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and that you would be sentenced before Judge Barr in 1482 District Court.
Yes.
Okay. Basis for the no contest plea.
Lack of memory, Your Honor.
All right. Understanding all of that, sir, do you still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
All right. You understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form today. Is that correct?
Mm-hmm.
Yes.
Is that a yes?
Yes.
All right. Any questions regarding any of those rights?
No.
All right. Look at paragraph 5. There's a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yeah.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Mhm.
And
Yes.
yes. Okay. And of your own free will.
Yes.
All right. Counsel, the court has been provided and has reviewed Ypsilanti Police Department report for their case number 2417267. Any objection to the court having reviewed that report?
None from the defense. Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could find the defendant guilty of the offense of assault and/or assault and battery. Counsel, have I complied with the court?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be January 22nd, 2025, 11 a.m. before Judge Barr. Welcome.
Thank you, Your Honor.
Thank you, sir. The court does call the case of the people versus Jemani Vanderloop.
Anna Mackey on behalf of Mr. Vanderloop, who is appearing to my right.
Bonnie Vanderloop.
Thank you.
Your Honor, at this time, we would like to set this matter for preliminary examination.
Both cases.
Yes.
Sir, discovery completing both of these matters?
It is, Your Honor.
All right.
That is not true. We don't have the 911 calls.
Oh,
They were requested, but we just have not received.
you
them.
haven't received them. If I put it out a week, we're gonna be able to get those, or?
Yes.
Probable cause conference, I'll adjourn out 1 week to the 16th, 2025, 9 a.m. on both matters.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Levante, Washington.
That's the one. People.
I said, Connection of the chair, I can feel Your Honor, on behalf of Mr. Levante Washington. Approaching, Mr. Washington, state your name for the record, please.
Levante Washington.
Thank you. You're requesting an adjournment.
You are requesting an adjournment,
How
Your
much
Honor.
more time did you need?
I did not hear you, Judge.
How much more time did you need?
I think 2 weeks will be just fine, Judge.
Without objection, probable cause conference, January 23rd, 2025, 9 a.m. Bond continues.
Esteban, Judge.
Oh, boy.
Yes.
Go ahead.
Your Honor, Mr. Washington was remanded at his last hearing because there was a positive test. He's asked that we address bond again today. I have made a number of contacts. I've reached out to his community corrections agent. She indicated to me that in order for him to get into CCOP while in custody, the court would need to send over an order to their attention so that they could at least start the process. However, he wouldn't be able to do the assessment until he's out of custody. So I guess our first request today would be that the court consider an order allowing him to enter the CCOP program so that he could be assessed. I also reached out to Matt Statman to see if he could come to the jail and do an assessment. I know that the court would like to see some type of plan in place to address his sobriety. He didn't want to address the court again today. He indicated that he wanted to.
What did you think about the vault? What did you think about going into the vault? What were you expecting?
Take responsibility and be open and honest to the court and explain to the court exactly.
So what changed? Why does he now want to be open and honest?
I think primarily, Your Honor, he indicates that he was extremely shameful of what had happened. I think he could better say it in his own words. His family is here. He knows that he's let them down significantly over the past few years. I think this started back in 2023, right?
Yes, ma'am.
Yeah. So he knows that he's let them down and he just has not been very open with himself about the extent of his addiction. He and I had a great conversation. He has a lot of insight. And he told me himself that he is not great with words, but he's going to do his absolute best to try and express himself to his honor so that he could see and understand where he is in regards to.
Is his mom and dad here?
They are. His mom is that your dad?
Mom and sister.
That's both of them.
No, this is my mom.
His mother is here, Your Honor.
What do you want to tell me?
First of all, I want to apologize for being dishonest with you. Like I say, whatever we can do to move forward and help me with
with the problem that I have, I just want to do the right thing, Your Honor. I'm not even gonna lie to you. Like I said, I'm not the best with words. So,
I'm understanding everything you're saying.
you know, I just ask for another chance. Honestly, I do.
Well, not funny, but why were you lying to me?
I was just in disbelief.
Did I look like that stupid?
No,
Huh?
no, I was lying to myself, honestly.
Point. But you had lied to your mother about that, right?
Correct.
Right?
Yes, sir.
Because see, most people don't think I remember anything, but Mama was sitting on that side. All of a sudden, you may not have seen this, but all of a sudden, her baby was about to be in trouble, and Mom came all the way from that side over here because Mom was going to jump up and say anything she could to try to defend her child. Mom, am I right? And then the biggest disappointment was on her face because she couldn't defend you. So more than what you did to me, more than what you did to yourself, you did that to your mom. And I'm going to tell you, the way I am, that sometimes is a harder thing for me to forgive when you do that to your mom. Because I when I saw her coming over, I said, oh, what's she going to do? But because she was going to battle for you. And that's who you really let down. You got me?
Yes, sir.
All right. So, Ms. Ecker, what kind of plan?
So, Your Honor.
I understand the CC. I get that part of it. But what kind of plan is in place for him so that I don't let him out of here and then next thing I know, I'm having to put him back in because he can't?
And Your Honor, I think that I spoke with Mom today, and I know he was on tether initially. And I think Mom, again, not realizing the extent of the issue, understood that he could not go, but people came to the house. And that's where his next level of exposure happened. And I told him, I said, the tether can keep you from going places and have the monitor you, but it obviously didn't stop you from testing positive. And he explained to me that it was due to influences that he had allowed back into his circle and his bubble. So what Mom has assured me of is that now that she knows that his access is not just based on him going out, she, with it being her house, is also going to limit or prevent anyone from coming in to see him, especially while he's in this very vulnerable state and until we can get him secured into some type of treatment. That was the commitment that Mom made to me today. I will say something too, Your Honor. When I had spoken with him, this is part of what I was expecting him to say to the court. I asked him, I said, so why did you lie? And he said, because my mom was there and I didn't want to tell her the truth. I wasn't here at that last hearing, so it is quite funny that the court is able to see exactly what the root of that particular situation was.
I could see it on Mom's face. I just didn't know who was going to come at. I didn't know if it was going to be at me or what it was going to be at, but I could also see the hurt on her face. And young man, you got to do better.
Promise to. I promise I won't drop dirty again.
All right, here's what I'm going to do. At this juncture, second really, I'm going to, well, is there anything from the people?
We'll leave it in your discretion, yeah.
All right, here's what I'm going to do at this point. Second really, I will I'm gonna deny the request right at this moment. I want in writing what is basically the plan.
Okay.
That it would be reinstated. He's not gonna have folks coming over to his mother's house, because young man, how old are you?
24.
Yeah, she does not have to give you a home.
Mhm.
You got that?
Yes, sir.
So I want that laid out, that this is what the defendant is going to do. I understand what mom's going to do in terms of protecting her house, but I want what his commitment is in writing. So if he messes it up, it's his word. It's not something mama didn't do. All right? And then I will consider, I'll look at that and based upon what we talked about, try to get him released. I want also in there the CCOP portion of that in the order, and then I'll look at and do that. Okay?
Okay, so we'll look at the order after we get you the plan.
You get us a plan and then you just prepare an order for
Absolutely.
these, but I want everything laid out, spelled out as to what he's going to do.
Understood, Your Honor. I'll work on that today.
You're not an amoeba. I'll have him look it up when he gets out as to why I'm saying it. He knows why I'm saying that.
Thank you.
I was just in the room and that's how I now go. Young man, you break that woman's heart. I don't know. There's a place in the jail and you will just be staying there. Hear me?
Yes, sir. Appreciate you, man.
Thank you. Mom, you take care. You didn't think I saw you, but I saw you. All right? You're welcome. Court calls the case, People versus Douglas Wren. 3 cases.
Court shall feature Assistant Public Defender on behalf of Mr. Wren. Mr. Wren, please state your name for the record.
Douglas Allen Wren.
All right. You're still looking for an evaluation from drug court?
Yes, Judge. The court signed an order yesterday to have Mr. Wren released to inpatient treatment. That's going to take, that's a process of at least 30 days. He asked me yesterday when I saw him in custody to talk to the people about the possibility of a drug court evaluation. And so we're asking for an adjournment to seek their approval and get him evaluated.
How much time you?
If we can go 3 weeks, Your Honor, that at least look.
During these January 30th, 2025, 9 a.m.
Can I,
Sorry, Judge. Hold on, Mr. Wren. What date did you give Judge? I apologize.
January 30th.
All right. Go ahead, Mr. Wren.
can Dawn Farms downtown, pick me up?
Judge, already signed the order for your release to treatment.
Yeah, to release for treatment.
The Dawn Farm?
Well,
I think
I think it's a general release.
Yeah.
So whatever's going to be available first.
Okay.
Okay. I think I had already signed it. All right. Okay. Thank you, Bond.
It's already in. You already signed it. You're all good. Thank you, Judge.
Thank you. Be done, but here we go. Court calls the case, recalls the case, People versus Tariq Day.
Brian Bowling on behalf of Mr. Day. Can you state your name for the record, please?
Tariq Day?
Your Honor, thank you for.
What did Bellinger do?
It wasn't him. It was.
No, Bellinger gave him the wrong date, didn't he?
Yeah.
I was wondering why Mr. Day wasn't here.
He sent a bad email, Your Honor, with the wrong date.
That's what I'm thinking. And it wasn't your fault.
No, I know.
I know, it was Bellinger's fault.
Just ask you to recall the warrant, Your Honor.
I'll recall the warrant.
Then we would ask that this matter be sent for preliminary examination.
Okay. And all discovery is complete.
It is correct. It is.
I was wondering where Mr. Day was. I was just like. Okay. Oh, you pulled me a new form. Got it. People have their witnesses available the 21st, 28th. Any objection?
Okay.
Preliminary examination will be set January 28th, 2025, 9 a.m. in person. Judge Barr. Bond will continue.
For the record, Your Honor, I wrote January 28th, 2025 at 9 a.m. on this piece of paper that I gave to Mr. Day.
Okay, all right, very good. All right, Ms. Day, take care.
Square in the interpreter.
You may.
Good morning, Madam Interpreter. Can you please turn on your camera, unmute, and raise your right hand to be sworn?
For the judge.
Hold on.
Madam Interpreter, can you please unmute and turn on your camera?
Oh, thank you, Mr.
Oh, there she is.
Now you just need to unmute. If you're in front of a computer, you can hold down the space bar.
Okay.
There we go.
Can you please raise your right hand? Sworn? Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Amharic and from Amharic into English in the manner now before the court to help you God?
I do.
Thank you.
All right. Good morning, Madam Interpreter.
Good morning. Excuse me. Sorry. Okay.
All right, you all set? Okay. Court does call the case of the people versus Medina Ishmael.
ፍርድ ቤቱ አሁን የሚጠራው መዲና እስማኤልን ነው።
Morgan Poisson for the people.
That was Morgan Poisson for the people.
ሞርገን ኮሳን የሚባለው ደግሞ የህዝቡን ወክሎ የሚናገር
Portia Feaster, Assistant Public Defender, on behalf of Ms. Ishmael.
Can you repeat your name, please?
Feaster, Torshell Feaster.
Portia Esther የሚባለው ደግሞ የአንቺ ጠበቃ ነው። የህዝብ ጠበቃ ነው።
Ms. Ishmael, would you please state your name for the record?
ስምሽን ለፍርድ ቤቱ ተናገሪ።
እሺ።
ስምሽ ማን ነው?
መዲና ነው። መዲና እስማኤል።
መዲና እስማኤል።
You're asking for an adjournment?
Oh, no, I'm sorry, Judge. She's asking for an exam. Ms. Ishmael is asking for a preliminary examination.
Cancel it.
Did you interpret that, Madam Interpreter? That defendant is asking for a preliminary examination?
የምትጠይቀው የመጀመሪያ ችሎት እንዲደረግላት ነው።
እሺ።
Okay.
Discovery is complete.
ግኝቱ ተጨርሷል። ጠይቀውሽ የሚገባውን ግኝት አግኝተዋል።
Yes, Your Honor.
አሁን ግኝቱ ተገኝቷል።
አልገባኝም።
ግኝት I don't understand.
Judge is asking me if I have all of the paperwork for your case.
ዳኛው የሚጠይቀኝ ሁሉንም የሚያስፈልገውን ጥያቄዎችና ወረቀቶች አግኝቻለሁ ወይ ብሎ ነው የጠየቀኝ።
Would the people have their witnesses available the 21st?
የፍርድ ቤቱ የሚያስፈልጉትን ሰዎች አግኝተዋል ወይ?
Can we please adjourn it out another week to ensure an interpreter is present for the victim?
She indicated, can we adjourn it out one more week so that we can have an interpreter available for the victim?
Do you need me to interpret that? የሚጠይቀው ያለው አንድ ሳምንት እንዲሰጠን ላንቺ የሚያስተረጉም ሰው እንዲገኝ።
አንድ ሳምንት
አንድ ሳምንት።
እሺ።
What was that, Madam Interpreter?
Uh-oh.
To postpone the hearing for 1 week so there will be an interpreter for the client. Or for the defendant. Excuse me.
Preliminary examination will be set January 28th, 2025, 9 a.m. before Judge Washington.
የመጀመሪያ ችሎት የሚደረገው በጃንዋሪ ማለት በጥር 28 በፈረንጆች አቆጣጠር በጥር 28 2025 በ9 ሰዓት ማለት ጠዋት በ3 ሰዓት የፍርድ ቤቱ ዳኛ ደግሞ የሚሆነው ዋሽንግተን የሚባል ዳኛ ፊት ነው የሚሆነው።
ቆሶሮ አለ?
ድገሚ።
ቆሶሮ ነው?
አዎ ቀጠሮ an appointment. So she is asking, is it for the appointment? For that day? Oh, sorry. Go ahead.
Yes, that's her next court date.
የሚቀጥለው የፍርድ ቤት ቀንሽ ነው ይሄ።
Okay. Her bond will continue. Thank you.
Thank you, Judge.
የመያዣው ገንዘብ ይቀጥላል።
እሺ።
Okay.
Thank you, Judge.
Thank you.
አመሰግናለሁ።
Mr. Feaster. Thank you, Madam Interpreter.
Thank you, Judge. Thank you, Your Honor.
Yes, we can go off. Court does call the case of the people versus D'Angelo Green.
Yeah. Echelon for the people.
Carl Burdell on behalf of Mr. Green. Good afternoon, Judge.
Good afternoon. Your name?
D'Angelo Green.
Thank you, sir.
So, Your Honor, I was just appointed late last night. At this time, I'm asking for an adjournment to the PCC. I have submitted the form to your staff.
Without objection, probable cause, January 23rd, 2025, 9 a.m.
Thank you, Judge.
Thank you. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Court calls case of the people versus Ian Edwards.
Assistant Public Defender Chelsea Virgil Clifton on behalf of Ian Edwards. Mr. Edwards, please state your name.
Ian Edwards. All right, thank you. All right, what are we doing?
Your Honor, we have a resolution. In this case, I have a plea form and a signed by civil rights form.
Oh, you have the plea form? All right.
Mr. Edwards would like to take the offer to plead guilty to assault and battery, dismissal of the felony with the understanding that he will be seeking HIDA.
Okay. And that's what the form represents, that he'll be pleading guilty to 93 days misdemeanor of assault and battery. That's the added count. 3 counts 1 and 2 would be dismissed, and that it is okay to seek HIDA. That's the court's full understanding.
That's correct.
Okay, have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Yeah, Edwards.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of assault and or assault battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
Yes, sir.
All right.
Hello, my name is Adam Ferrari, the Chief Executive Officer of Phoenix Energy. I look forward to you joining.
The court also does have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, sir.
And so you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are a part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of everyone.
Yes, sir.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or force you in any way?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On July 27, 2024, at the location of 601 West Stadium Boulevard, City of Ann Arbor, Washington County, State of Michigan, what do you do with Jonathan Williams that makes you think that you're guilty?
I punched him in the eye, sir. Punched him in the eye, sir.
Okay, and you did that intentionally?
Yes, sir.
And so you didn't have his permission to do that?
No, sir.
All right. Counsel, I think we have it.
Sufficient factual basis, sir.
All right.
Defense is satisfied.
All right, court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 50th District Court probation. Sentencing will be February 6, 2025, 1:30 before Judge Valvo. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Thomas Ellis.
National Law for the People.
Why are you looking at her? Is it your case, Dollinger?
No, it's not my case.
Okay.
We're trying to find whose it is.
It is. Oh, and we were just talking about this. Back in, see, I knew it was not going to take all day for you to blow it. It just, no, it wasn't going to take all, you, so everybody knows. I happened to see my good friend here during the break. I told her she had a good morning. That things seem to be going well for 2025. She said, Judge, I'm on it. I'm on it. I hear the first initial of the client called. I'm right there. Right? We come back from the break. First case with her on it. Can't find it.
I said block.
I made it clear she wasn't going to make it to February. But I know.
Half hour.
Yeah, right. I like it. He's gonna jump in too. Your name, sir?
Thomas Ellis.
All right, thank you. All right. What are we doing now that you're here, counsel?
Now that I'm here, Your Honor, we would be requesting an adjournment. We wanted to put together some mitigation information for the people to review.
All right. How much time would you need to get
Can
that?
we do a month, Judge?
All right. Without objection. Probable cause conference will be February 6th, 2025. 9 a.m. or as your invite indicates, bond will continue.
Thank you so much, Your Honor.
Thank you. Thank you, Mr. Ellis. No, you do what you get. You go do what you got to do. Court calls the case. Bless you. People versus Ariane Ellie Dawson.
Morgan, please not to
Assistant Public Defender Asli Bashir on behalf of Mr. Eli Dawson.
And sir, can you unmute and state your name, please?
Yes, can you hear me? Sorry.
Yes, we can hear you now.
Yeah, my name's Arian Ely Dawson.
All right. Okay. What are we doing?
We would like to set for exam.
All discovery is complete?
Yes, as far as we know.
Do people have their witnesses available the 21st?
Can we go out another week, Jim?
No. Yes, we will. You don't have any objection to that, do you, Counsel?
No objection.
Preliminary examination, January 28th, 2025, 9 a.m. before Judge Barr. Bond will continue. That's in person. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Taiwan Griggs.
That's the one for the people.
I spoke to Mr. Griggs. He has a guardian. He is incompetent, and right now he has been involuntarily committed. He is at Sacred Heart. I confirmed this with his guardian. I tried to confirm it with Sacred Heart, but they would neither confirm nor deny his presence. He did call me today. And in speaking to whoever was there beside him, they said they wouldn't let him do anything because he has a guardian, so they won't allow him to sign the release of information without her consent. Your Honor, I am simply asking for an adjournment of this matter so that I can get the release of information.
Got a green sheet.
What?
Did you get a green sheet?
Yeah. What? No, but okay.
And Your Honor, I have no reason to doubt anything the defense counsel is saying. I will note to the record, though, it looks like we've had prior PCCs in this case, 1031, 1121, 1226, and the defendant hasn't answered any of them.
Have you had communication with the guardian?
I spoke with her yesterday regarding getting the release of information. She was at work, which is how I'm assuming he was able to call me today because I sent her my business card and everything else. And so she is trying to get a release of information. She said when she calls that number that Sacred Heart has given her, it just rings. But again, she was at work at the time, so.
Well, I'll grant one more adjournment to the 23rd and try to get that at least solidified.
Work for you?
January 23rd, 2025, 9 a.m. bond continue. Court calls the case People versus Mohammed Haji Jelani.
Ashley Lonnie for the people.
On behalf of Mr. Haji Jelani, state your name for the record, please.
Jelani, good morning.
How are you, sir?
I'm good.
We're just asking this matter be set for an exam here.
All discoveries.
It is.
People have their witnesses available the 21st.
We'll try, Your Honor. Thank you.
Preliminary examination in person, January 21st, 2025, 9 a.m. before me.
So Tuesday, like
bond will continue.
2 Tuesdays from now.
Thank you, Honor. Hope you have a good day.
You too.
Okay.
Thanks, John.
All right. Court calls the case People versus Mary O'Hearn.
Andrew Childs is on behalf.
Assistant Public Defender Ashley Bashir on behalf of Mr. Hearn.
Your name, sir?
Mario Hearn.
Thank you. You're requesting an adjournment.
Yes.
Without objection, probable cause conference will be adjourned January 30th, 2025, 9 a.m. Bond will continue. Mr. Hearn,
Yes.
I heard you were surprised I was here.
Oh.
Right? I'm here all the time, so, okay. Appreciate it. All right, you take care.
Your Honor.
Court calls the case, People versus Lonnie Howard.
Public Defender Hannah Apple appearing on behalf of Mr. Howard. Mr. Howard, will you please state your name for the record?
Lonnie Howard.
Your Honor, we're asking that this matter be set for a preliminary examination.
Discovery is complete.
To our knowledge, yes.
You have other witnesses available the 21st?
We'll do our best.
Preliminary examination, January 21st, 2024, 9 a.m. Quiet, Emily. That's before Judge Moore. Bond will continue.
Your Honor.
Court calls case People versus Phyllis Lindblade.
Ashley Watt.
Assistant Public Defender Jay Ballinger on behalf of Ms. Lynn Blade, who appears via Zoom, Your Honor.
When we hit that first 1 million in sales in our first year of business, it was surreal. Like, this is definitely going to be a thing.
From our tradition to yours, Stonefire. Together, we none.
Damn.
Oh, there she
Your
is.
Honor, I'm Yvonne Davis, and I'm the guardian for Phyllis Lindblade. This is her.
Oh, okay, there she is. Okay, gotcha. Okay, thank you.
And Your
Yes.
Honor, I have requested an adjournment on this matter for reasons being that I have not been able to be in contact with Ms. Lindblade herself over the last couple of weeks. I did get in contact with Ms. Davis, the guardian. However, I need Ms. Lindblade's permission to sign her name to some certificates of release from the Humane Society. I can't get that permission from the legal guardian. I don't know if Ms. I'm sorry.
Say that again.
I cannot get legal, I can only get legal permission from Ms. Lindblade herself. I can't get it from the guardian in order to sign this paperwork. So I need Ms. Lindblade's permission in order to do that. That's
why
that is our office policy, if nothing else.
And it's the surrender paperwork for her ownership rights in the animals, Your Honor. That's the paperwork.
But that's her legal guardian.
I understand, Your Honor. If nothing else, that is our office policy. I have been able to confirm that.
That's office policy that doesn't conform to the law, because if the guardian signs off, that's as if she is.
I understand, Your Honor. I just, because of that, I'm uncomfortable doing it. So I would need Ms. Lindblade's permission. She hasn't been, I've tried to contact Ms. Lindblade herself. I don't know if she has her phone available. I have a good number for her, but Ms.
Council approach, please.
Tell him my phone is lost.
Hold on.
How do you get permission?
I don't know that her legal guardianship has competence, Your Honor, just her medical.
Yeah. And how to document you covers the dossier.
All right, pretty much. Okay. Thank you.
So, Your Honor, I would propose that I speak with the guardian again on this matter. I would ask for a couple weeks in order to do that.
Probable cause conference will be adjourned January 30th, 2025, 9 a.m.
Thank you.
All right, bond will continue.
Thank you.
Thank you, folks.
Thank you, Your Honor.
Thank you.
I think this is going to 2034.
People versus Sean Lutman.
Okay, Stephanie Cannon on behalf of Mr. Lutman, who is appearing by Zoom, Your Honor.
Mr. Lutman, can you state your name, please?
Sean Lutman.
All right.
Your Honor, the last time I checked, we were waiting on the 911 call that came in. Did you get it?
No, so Your Honor, when we were last up on the 19th, the defense requested 911, and I immediately sent an email over to the state requesting it. And yesterday, Ms. Cannon naturally asked if I'd received it, and I thought to myself, that's a great question. I sent an email over there. They apparently sent it, but I don't know how they sent it, and I don't have any record of it arriving in our system. So all I see was checking with the person at the Brighton Post that handles that. I was hopefully expecting an update by now, but I don't have it. The question is whether they sent it on a physical disk, which would be unlikely, or an evidence.com link. So it exists, it's out there. We just have to figure out where it is.
Got it.
We should be able to get it, though I don't see any reason why not.
All right, why don't I? 30th or 23rd, she think.
Your Honor, I mean, because he's asking for a preliminary exam, so you need till the 30th?
I don't know if the judge is.
January 23rd, 2025, 9 a.m.
Thank you, Your Honor. Can we ask permission?
You guys went too long. What?
And that's perfectly fine, Your Honor. Can we ask permission for him to appear by Zoom? If you remember, he's paraplegic.
Absolutely.
Thank you.
All right. Thank you, sir.
Thank you. Goodbye.
Court calls case, people versus, is it Dorinian Lee Marshall?
Public Defender Hannah Apple appearing on behalf of Mr. Marshall, who is approaching now.
Okay.
Mr. Marshall, will you please state your name for the record? Your Honor, there is some outstanding video and 911 call that we need to review, so I'd ask for an adjournment.
2 weeks be enough?
I believe so.
Probable cause conference, January 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you.
I'm going to give you this notice.
Court calls case of the people versus Nicolene Mason.
Ashalani for the people.
Brian Boyd, we have Ms. Mason, Your Honor. She should be present on Zoom, Your Honor.
Hello, I'm here.
Yeah, you're here. All right. Hello, Miss Mason.
Simpson, I'm not doing good. I had a seizure yesterday. Listen, I don't have internet right in my apartment, so I have to come across the street to my neighbor's apartment to use her internet. Anyway, after I got off of 2, I didn't get over Judge Perry. As I was going down the steps, I fell and had a seizure.
Oh, my goodness. Okay.
So I'm 53 years old, so I ain't doing too good today. I'm hurt.
Okay. All right. We'll make this quick. But you got to Judge Perry yesterday, right?
No, I didn't. I'm going to get on it. As I was going to go on there, I fell down the steps and had a seizure. Literally, my neighbor right here.
Okay, so you didn't get over to that.
They had to help me.
Okay. If it at all is helpful with that, have her call me and I'll tell her you showed up for both your hearings before me. So, all right.
So what I'm going to do is I'm going to call the number on this letter that I got the other day from her court and find out what day I could come or whatever.
Okay.
Okay.
All right.
I'm going to take care of it though. I'm not trying to elude or avoid anything.
Miss Mason, I know you're not. Yeah. And Miss Mason, you make sure to do that. I'm going to have my staff email Judge Perry's staff to let her know that you were before me on that day, so that if that helps you out at all, okay?
Thank you, sir.
All right. All right.
But we get an exam date. All discovery is.
You want an exam date on that? Okay. All right. So all discovery is complete.
Yes, sir.
People have their witnesses available the 21st.
Jared, can we please go one additional week?
No objection.
Preliminary examination. Pardon?
I was saying we don't need no witnesses. I am definitely, what I'm accused of, I did.
You don't need any witnesses?
No, sir, I did what they
Oh,
say I
oh,
did.
Miss
I just
Mason,
wanna
now hold
get it.
on, Miss Mason. Miss Mason, hold on. Hold
Okay.
on. Well, you let your attorneys handle that part, okay?
Okay, sir.
Okay, just put your.
Okay, sir.
Just trust them, okay?
Okay.
If they think that the people should bring their witnesses, just go with it.
Okay.
Okay. January 28th, 2025 at 9 a.m. before Judge Washington.
Okay, so do I go Zoom or do I come in person?
You got to come in person on that day.
Okay, so where is that at? In your courthouse?
Yes, it's in the same courthouse I'm in. There'll be different judges up here, but it's the same place.
Okay. Well, my attorney, he can hear me, right? Just make sure you let me know, remind me and stuff, so I can make sure I got up here.
Okay. All right. Yeah. Make sure you let her know.
I made a note.
You hear that?
I will.
Yes,
All
sir.
right. Because Miss Mason has spoken. All right, Miss Mason, you take care.
You too. Thank you, Judge Simpson. I appreciate you so much.
Yes, ma'am.
Thanks, Judge.
You have a blessed day.
Court calls the case, People versus Jacob Miller.
Any for the people?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Miller, who's approaching now, right up here. Will you please state your name for the record?
Jacob Miller.
Thank you. Your Honor, my understanding is that there is take your hands out. That there is a referral for competency that should be in the file.
Yes.
We're asking that the court sign that order and then set out a
Competency hearing date.
Yes.
All right. A forensic evaluation is ordered. Set a competency hearing date out. April 10th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
You're all set.
Court calls case People versus Cody Moore.
Assistant Public Defender, Chinaza Ikeri Akinruli, Your Honor, on behalf of,
Back on track.
I'm back on track. On behalf of Cody Moore, Judge.
Your name, sir?
Cody Moore.
All right.
We respectfully request to set this matter for preliminary examination,
All discovery is complete.
to my knowledge, Judge.
And would the people have their witnesses available the 21st?
Your Honor, can we go one more day out? This will require a witness from the parole office. Available on that day. Actually, she is available on that day. We can do that day.
What's the date?
21st.
Thank you, Your Honor.
Preliminary examination in person, January 21st, 2025, 9 a.m. That is before Judge. Oh.
It's
before me. Didn't mean to say it that way. Bond will continue.
Thank you, Your Honor. Yep.
Thank you, Your Honor.
Thank you, sir. Court calls the case, People versus Taisha Morgan.
Thank you.
Ready, Judge? Court show feature Assistant Public Defender on behalf of Ms. Morgan. I'm told she's on Zoom.
Well, her name's there. Ms. Morgan?
Yes.
Okay, there she is. State your name.
Taisha Morgan.
Okay.
Thank you, Judge. It looks like Ms. Morgan was communicating with a different attorney in my office and not myself, so I have not spoken to her. So I need an adjournment so that we can.
So what'd the other attorney say? Never mind. That's privilege.
Yes, sir. So I apologize. We can get a brief adjournment, Judge. Hopefully Ms. Morgan and I can connect.
January 23rd, 2025, 9 a.m. Bond continue.
Thank you, Judge. I'll call you, Ms. Morgan.
Okay.
All right. Take care, Ms. Morgan.
You too. Bye-bye.
Court does call the case, People versus Thurman Pool.
Assistant Public Defender Chinaza Ikeri Akinruli, Your Honor, on behalf of Mr. Thurman Poole.
Your name? Thurman Pool. Thank you.
Judge, we're asking for an adjournment in this matter.
Of course, you. How much time do you need? 2
3
weeks
weeks
of
is
work?
fine. Yes, Judge. Thank you.
Probable cause conference, January 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case, people versus, is it Yair Sanchez Ortega?
Ask a lot of people.
Brian Mulling on behalf of Mr. Sanchez Ortega.
Sir, can you state your name, please?
Yair Sanchez Ortega.
Thank you.
We're asking for an exam. Discovery is complete.
People have their witnesses available the 21st?
Okay, Your Honor. Oh, we'll try for that date, Your Honor.
Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls the case, people versus Patsy Shear.
Morgan Poisson for the people.
We're Phoenix Energy, a family-owned oil company focused on unleashing American oil from North Dakota and
Assistant Public Defender Chelsea Virgil with and on behalf of Patsy Shear, who appears via Zoom. Ms. Shear, please state your name.
Patsy Shear.
And you're requesting an adjournment?
Yes, Your Honor.
Other, gotcha.
We've reached a global in this matter, so for the defendant to avail herself of the plea in this case needs to be first. That is up. I'm sorry, when is the next?
Your Honor, that's on the 16th. We would ask if you don't mind, could she please have her probable cause conference also on the 16th to resolve both cases that day?
Say again?
The 16th is her pretrial in the other case. She has to plead on that first. We're asking for you to set the probable cause conference also on that date.
What time is her hearing on the 16th and where?
It's at 9 a.m. I believe it will be here.
It's in front of Judge Freshour.
Ah, got it. Okay. Okay, I'll adjourn it out a week under those circumstances. January 16th, 2025, 9 a.m.
Thank you.
Bond continue.
I'm sorry, may I address the bond conditions?
You want bonds? She's out.
Well, I would like to keep the personal bond if possible, Your Honor, but the conditions I would like to address.
Oh, so now you're getting nitpicky. Go ahead.
Your Honor, we have two humble requests for you today. We ask you to consider first allowing her to do drug and alcohol testing at Dawn Farm, where she resides. She's in transitional housing, which I provided paperwork to show.
Do the people have any problem with that, provided there's a release?
No.
All right, then you can prepare a stipulated order to that issue. What's your next one?
We are asking again for you to consider consensual contact. Her family has expressed to me, she has an aunt, she has a supportive family, and both her and her family have expressed to me that it's difficult for the kids to have their parents not have contact. They've always been raised together, so just to continue raising their family together, we're asking for consensual contact. Ms. Shear has, I believe, behaved exemplary while on bond. I understand there was an instance of contact, but aside from that, she has been really dedicated to improving herself, completing her treatment at inpatient home of New Vision and now at Dawn Farm, with both mental health and sobriety, really committed to improving herself. And I ask you to consider just consensual contact.
I don't think it's appropriate at this time. If this case was picked up while another case was pending, and then there was, I'm sure as the court remembers,
yes,
the contact violation. I'm very glad to see that Ms. Shear is taking her treatment seriously. It seems like it's going well. This seems like there's going to be a resolution in just a couple of weeks. I would like to get to that point and have it be solidified, have her continue to earn that release. I understand it's difficult for the children, but at this time, given the history of this case, I just think it's a bit premature.
And the court would agree. So what I'm going to do is I will grant your request for a change as to the drug testing issue. I will deny it as to the no contact provision.
Okay, thank you.
Thank you.
Thank you.
Court calls case People versus Eric Smith.
And on behalf of people,
And I said, it was approaching. Please state your name for the record, Mr. Smith.
Eric Smith. Thank you. You're asking for an adjournment.
Yes, Your Honor. 3 weeks, if possible.
That objection, probable cause, January 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
That works.
Court calls case People versus Deion Stanley.
Ashley Long for the people.
Assistant Public Defender Chinaza Kiriakin, on behalf of Mr. Deion Stanley, who is approaching. Mr. Stanley, when you get here, could you state your name for the record, please?
Deion Stanley.
Thank you.
Judge, we request that this matter be set for, you want
I
to?
wanted to adjust the, can I adjust the court? Can I say something?
It all depends on what you're going to say.
Oh, I've been, my papers told me to be here at 9 o'clock on the dot. I was here at 9 o'clock on the dot. My paper said be here at 9. And I went to my job first and told my boss I had court at 9. And I've been here at 9.
But you get placed into a block.
Yeah. And
Right. Everything is set at 9. You get placed into a block. Your attorneys send out communication to you as to what the time is.
And then, you know.
And I think the issue, Your Honor, is that Mr. Stanley maybe did not receive the information as to what time his block was going to be. So he did appear here at 9 o'clock. He and I had spoken earlier, and he was a bit discouraged when I did tell him that his block was at 12:30, and at that point, it didn't make sense for him to leave. So he's just a little frustrated that he's been here since 9 o'clock.
And I told my boss I was gonna be back at 12. And now I'm about to just miss a whole day of work. He gave me the opportunity to work a half a day.
Okay, but I know the communication would have gone to your email address by the public defender's office. So I understand what you're saying. I don't know what you want the court to do about that. Because it's not as though they didn't do what they.
I'm just saying, I seen people come in late, get seen, and you even said that you came in late. I don't know. Maybe I haven't been in trouble in 20 years, so I don't.
Okay, but I don't know what you want me to do.
I think he's just more so expressing some frustration to the court. There is no remedy for
I
that.
understand that. There isn't a remedy for it. The only thing I can tell you is that I know that everything gets set basically by me at 9 or at 3, technically. And so the thing is that you've got to keep on top of your communication from your attorney's office, because they tell you what time block you end up in. So what are you asking to have? You want a preliminary?
That is correct, Your Honor.
All discoveries complete?
So our understanding,
And would the people have their witnesses available? And the 21st?
Checking, Your Honor. Now, we just go to 28.
Preliminary examination in person, January 28th, without objection. 2025, 9 a.m. in person before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Robert Suggs.
The judge.
Some of my kids are top of their class, and I fully attribute IXL to helping them reach that goal because of
Could you state your name for the record, Mr. Suggs? Got to speak up for the judge, okay?
Suggs. Thank you, sir.
Your Honor, my client is asking to exercise his right to a preliminary exam in this matter.
All right.
To my knowledge, all discovery is complete.
People have their witnesses available the 21st.
Try, Your Honor.
Mr. Suggs, I'm going to set your preliminary examination in person, January 21st, 2025, 9 a.m. before me. Okay?
But we'll be back on the 21st.
21st. Okay, sir.
Yeah. Okay, Mr. Suggs, we're all set.
Okay, thank you, sir.
Mr. Suggs, we're all set. We're all set.
Thank you. Thank you, sir. I notice your patch there. Are you military?
Are you in the military, Mr. Suggs? Were you?
Which branch?
Which branch? 96 Marine Corps, Your Honor.
God bless you. Thank you for your service, sir. 21 to 22 years. Long time. Long time. Court calls the case, People versus William Sumler.
Assistant Public Defender Chelsea Richfield with and on behalf of William Sumler, who appears via Zoom. Mr. Summer, please state your name.
William Sumler.
All right, I have before me a plea form that indicates that the defendant will be pleading no contest to attempted larceny, 200 to 1,000. That is a misdemeanor punishable by up to 6 months incarceration. Upon a successful plea to that charge, the felony would be dismissed. There is an agreement also to no delayed or deferred, although I cannot find the sentencing court.
That is correct.
All right. Is that a correct statement, counsel?
Yes, Your Honor.
All right, very good. Sumler, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for the record, please.
William Sumler.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of attempted larceny, 200 to 1,000. That is a misdemeanor punishable by up to 6 months incarceration and or a $1,000 fine plus court costs. Do you understand that?
Yes.
All right. You understand what a no contest plea is, sir?
Not exactly.
Okay. A no contest plea, first of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
All right. Second thing that you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty to the charge. You understand that?
Yes.
All right. The other thing is that the court has been provided and has reviewed a police report in this case. I would be taking those facts as true to determine whether or not there was a crime that was committed and that you committed that crime. You understand that?
Yes, sir.
Okay. Do you have any other questions about a no contest plea?
I don't, because I don't want to make my attorney look bad. But I didn't do anything.
Oh, hold on. All right.
And
hold on. Mr. Sumler, hold it. I don't think you're necessarily.
I don't want to do no time in jail. Like, I didn't do nothing to do no
Okay,
jail.
Mr. Sumler, stop.
Okay.
Stop for a moment. Okay. Here's what I'm going to do, because I think you need to have, sometimes cases, regrettably or beneficially, are about getting somebody to a safe spot. So you're not making your attorney look bad. You're not doing anything. If you don't want to plead or you're unsure about something, then my job is to try to make sure that you are sure about what you're doing. So what I'm going to do at this point is I'm going to stop this plea. I'm not going to take the plea. I'm going to adjourn this out a couple weeks, let you talk.
When your severe asthma says you can't,
In detail, get all questions that you want to ask your attorney, so you understand exactly what you're doing and why.
Right, because my thing is, Your Honor.
Because no, I don't need your point. That's what we're doing. I don't want you to say anything that may incriminate you in any way. I just don't want you to say anything. Based upon what you've already said, this is what I'm going to do. Okay? And then I want the next words that come out of your mouth, other than say, thank you, we'll see you in 2 weeks, should be said to your attorney. You hear me?
Yes, sir.
Probable cause conference in this matter will be adjourned to January 23rd, 2025 at 9. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Sumler. We'll see you in 2 weeks.
Thank you. You have a good one.
You too. Court calls the case, People versus Cynthia Settle.
Absolutely, for the people, Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of the Settle, state your name for the record. Judge, we are, oh, did I put a green?
What's wrong?
Oh.
I have it. You don't even know what you're doing now, do you? You're operating so fast and on time, you have no clue what you've done and what you haven't done. Isn't that right, Ms. Atkinson? You just...
You know, we are requesting an adjournment, Your Honor. We would like to ask that the court enter an order. There are restitution payments that need to be made on this in order to get the offer to the people. She did try and make the payment, but she was told by the desk at that they need an order.
And they... Go ahead. Oh, we can't take the payments here. So we can't take them at this location.
Okay.
She'll have to pay downtown.
At the circuit court.
15.
Okay.
But I can, no, not at circuit court, at 15th district court.
Okay.
Is there, and I'll write this on it, but how much is she going to pay total?
Right.
What we'll do is $2,800.
So the payment that she wants to make today, Your Honor, is the
I'll make that 28.
Okay, the entire payment, Your Honor.
Today?
She was ready to pay it today and she went.
She was ready to pay $2,800?
You know, and they rejected
our
it.
clerks didn't?
They turned her away, yeah.
Okay.
How much? 30 days.
So what I'm gonna do is I will indicate on this form that defendant may pay up to $2,800 in bond to be held as restitution. And so I put that on here, and then hopefully when you go downtown, they'll take the funds. All right. How much time did you want me to turn this out?
She's requesting 30 days only because she has to give 30-day notice to her job for taking time off.
Do you have to do that?
You know, I can't.
No.
I don't even know how to request
They don't even
time.
know how, I know you don't have to respond.
Yeah.
You need 30 days
It
to.
would be nice, because we've been.
Yes, sir. So if I gave you till February 6th, would that work?
Yeah.
That will work for, okay. Probably, without objection, probable cause will be on February 6th, 2025, 9 a.m. Bond will continue. You're welcome.
Thank you so much, Your Honor.
Good to see, Ms. Akinrule, that you are seated first at the table. So, just in case, huh?
Hearing on behalf of defendant Cynthia Rauberger, who is standing to my right, Your Honor.
So, Your Honor, interestingly enough, I was reviewing everything with Ms. Gurdon before the docket, and we were Ms. Rauberger has a case pending in Jackson. I was curious why she had this felony here. In so doing, I discovered that one of the priors that we used to enhance this was actually Nolly Cross. So this case correctly charges felony, and it should be an OWI second. My question to the court for today's proceedings are, if the court wishes to remand it now, in knowing that I will file an amended complaint, or I can have an amended complaint filed with the court. We come back in a couple of weeks, and then it gets remanded once we have that amended complaint by second as the charged offense.
Do you have a preference? No.
Your Honor, if we could just remand it so there's one last court hearing, that would be good.
Yeah, I don't see why we just don't remand it down to 454.
I do not have.
All right. That's an OWI second.
So there is a 2022 in Jackson conviction as it's listed as an enhancement. That is the one that was Nolly Cross with the 9/19/23 conviction.
So the 23 is the valid
Yes. Yep.
conviction. Gotcha.
Build a website you love with Wix. Where your words.
How that actually is going to look is that the Smiths count 1, right? And then remanded on what really is going to effectively be a count 2. That sounds funny, but that's the way it's going to work, which is an OWI second offense. The defendant's plea of not guilty will be maintained. I'll set a pretrial. We have a pretrial date for Judge Frisco. January 28th, 2025, 9 a.m. you said? 10 a.m. And that would be before Judge Freshour. All right. Her bond with its conditions, however, at this stage will continue.
Can I address something with the court regarding her testing? Miss Romberger lives out of Jackson. Currently, she's testing here in Washington. We were wondering if she could be able to test in Jackson.
She could test, you can prepare an order to that effect. Actually, at this point, we need to be signed by Judge Freshour.
Okay.
That she can test in Jackson, but part of that order, at least for me, is that there be a release of information to send the information to community directions.
Okay, thank you.
All right. Okay, thank you.
Your Honor. Have a
Good stuff. Court calls case of the People versus Isaiah Adams.
Good afternoon, Your Honor. Amy Rides on behalf of the people.
Afternoon, Your Honor. Dan Garrett on behalf of Isaiah Adams.
Your name, sir?
Isaiah Adams.
Thank you.
Your Honor,
go ahead.
Your Honor, we're asking for an adjourned probable cause conference to the 30th, and may Mrs. Reiser and I approach very briefly. Very briefly. Or just me.
Miss Reiser can. No, come on. I will adjourn probable cause then in this matter, January 30th, 2025, 9 a.m. As your invite indicates. Bond will continue. There was a request for a modification or condition thing on bond off of the record. As I've indicated, Mr. Guerin can explain it to his client. I'm going to deny any request or change.
Understood, Your Honor. Thank you very much. I'll explain that to Mr. Adams.
All right.
I'll meet you guys.
Thank you. Court calls case, People versus Natalie Guzman.
Andrew Kulis, appearing on behalf of the people.
Afternoon, Your Honor. Dan Garrett on behalf of Natalie Guzman. She's stepping forward.
Your name, ma'am?
Natalie Guzman.
Okay. And I have before me a plea form. Indicates she's going to be pleading no contest to the charge of larceny less than 293-day offense. On her successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement, and if it's a no contest plea, counsel, I don't.
Your Honor, in my right hand, I'm giving that to Deputy Allen.
Okay.
I'm sorry I didn't get that to you sooner. We just worked out the mechanics of that this afternoon.
Oh, yeah, I got it.
Yeah.
No, it's okay. I'll get
A pretty easy, quick read.
Is it? Okay.
Yes.
All right. So that's the people's understanding also?
Yes, Your Honor.
All right, very good. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God. State your name.
Natalie Guzman.
All right. Ma'am, it is this court's understanding that you're going to be pleading no contest to the charge of larceny less than 200. That is a misdemeanor.
Hello, my name is Adam Ferrari, the Chief Executive Officer of Phoenix Energy. I look forward.
Punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased 3 times the value of the property taken. If that's greater than $500, that could become the maximum fine. You understand that?
Yes, Your Honor.
Okay. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things I will explain to you is that it first of all means that you're not desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
All right. Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea?
Our lack of memory.
All right. Ma'am, to this charge of larceny less than 200, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of rank.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
No, you're on bond conditions.
Oh, I'm on bond. Your Honor.
Okay, so you're not on probation or parole.
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
and of your own free will.
Yes, Your Honor.
The court has been provided and is reviewing or has reviewed an Ann Arbor Police Department report for their case number 24-57223. Any objection to the court having reviewed that report?
Objection.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be February 6, 2025, 1:30 before Judge Valvo.
Your Honor, unfortunately, I have a travel request at the appropriate time. If there's an appropriate time.
No, you can go. There never is an appropriate time for you, Karen, but go ahead.
Your Honor, my client has previously been given permission by Your Honor to leave the state, but she needs to go, is asking to go again, this time for a work trip in Hawaii.
Right.
Yes.
No, I'm sorry. Sure.
Actually,
it's a work trip.
Your Honor, the event's start date, why don't you tell them the dates of proposed travel?
January 17th and return, I believe, on the 23rd.
A week in Hawaii for work. In January.
Not a bad
Yeah, exactly.
I printed.
Look, no, he's
I had
right.
a
No,
feeling.
ma'am, I believe you. Yeah, that's right. We're all apparently going to Hawaii to handle this hearing I'm sitting on that date. Counselor, if you just send me an order, I'll sign off.
I will, but we have one, she's been testing all clean. Is it possible she does an ETG when she returns or some sort of alternative?
Any objection to that?
Okay.
All right,
I'll get an order.
put that in the order.
Will do.
And get that over to me as soon as you possibly.
Gonna get this afternoon. Thank you, Your Honor.
All right. Thank you.
Thank you.
Bond will continue in
Great.
all other aspects. And ma'am, Godspeed to you on your travels.
Thanks, Your Honor.
I'm supposed to go to work at Tahiti. Court calls the case People versus Devin Morgan.
Andrew Chill is appearing on behalf of people.
Good afternoon, Your Honor. Allison Castles, Garen Law Group, on behalf of Devin Morgan.
Your name?
Devin Morgan.
Hold it. Just a minute. He left the room.
I know.
I was left unsupervised.
I know. It's like so cool, right?
Yeah.
I actually yelled at him about it. I told him you didn't just let her go. Just let her.
Worked.
Yeah, no, that's good though. So start doing something crazy so that we can think, what the heck, man? No, go ahead.
All right. If you make something up, I'll go with it. All right. We're just going to ask to adjourn out for another 3 weeks to allow for ongoing.
She was fine. All right. He's coming back in checking. Go ahead.
We would just ask to adjourn out another 3 weeks to allow for ongoing discussion with prosecutors.
Okay, 3 weeks is that any objection from the people? All right. Probable cause conference, January 30th, 2025, 9 a.m.
Thank you.
Bond will continue. Thank you, ma'am. Let's call the case of the People versus Earl Carver.
And that's on behalf of the people.
Alice Friedman for Earl Carver, who's present. Mr. Carver, would you stand here to my right, please?
Your name, sir?
Earl Carver.
All
right. Your Honor, I was just recently retained on this. I got the police report yesterday. I'd ask for 3 weeks on this, and then I do want to address bond.
Okay. That objection, probable cause conference, January 30th, 2025, 9 a.m. Yes, that's the bond.
That'd be 9 a.m.?
Pardon?
That'd be 9 a.m.?
Yes, 9 a.m.
Okay.
Kind of.
Yeah.
Or as your invite indicates.
Okay. In this case, Your Honor, there was a bond that was issued. That was issued was no contact, which doesn't for the Carvers. They have a family business together. They have a construction company together, and they're landlords together, and they have to communicate. We are willing to stipulate to email and text message contact. We can live with that. I don't think he can do much in the way of threatening or harassing if there's a record, a written record of emails and texts. And then as far as living is concerned, he was barred from both their properties. They have a house, family house in Manchester and a cottage in Irish Hills.
Value of having a partner is huge. Finding someone you can trust is what really builds the business from the base.
Mrs. Carver would prefer that she go to the cottage and he take the family house. And Manchester takes the livestock that he takes care of.
So which, is it the Keys one that you want to be in?
Yes.
That's the one. Okay. Anything from the people on this?
Your Honor, as to the changing the no go to, we would be amenable to that. However, we prefer to do that through stipulation to ensure there's no overlap of contact between the two parties. And then as to the no contact, we would be opposed given the facts of this case and some of the answers that were given, the assessment. We would be opposed to any contact between.
Okay, but I think what Mr. Friedman is in part asking is that any contact, that not to entirely lift the no contact, but that it be by email and text.
Correct.
We would still be opposed to that, Your Honor, given the facts of the case.
All right, here's what I'm going to do on this, given the circumstances of this particular case, is I will modify the no contact provision. No contact will remain in place, but consensual contact only by email regarding the family business and, well, regarding the family business, which also includes the rental properties, right? I mean, that's all a family business.
Yes, sir. Rental properties and the construction company.
Yes. So that would have to be specifically laid out. So consensual contact only as to those things.
Yep.
All right.
Need this.
Back on the Carver matter. What were you saying?
I just wanted to clarify that the no go to would remain in place until we had confirmation that Ms. Carver was out of the burial home and in the cottage, and then we would modify no go to through a stip.
Well, I think it's, I mean, I don't have any problems with that procedure, but there are two addresses. And so my understanding is that, do we know which one she preferred? Because we had basically said he was going to be at the Keys address.
Yes, we do know. She's here and to express.
Oh, she's here. Oh,
she expressed it to the advocate. Right there.
So are you out of that one property, ma'am?
Which is why we want confirmation that should be out of the.
I'll leave the house before she's back. Yes.
Okay. So that I'm clear. Mr. Carver is going to reside at the Keys Road address. The other address, Mrs. Carver will be residing at. The Edwin? Okay. So, and ma'am, that arrangement where he would be residing there, that's acceptable to you? Okay. She has acknowledged that, so I don't know that. I think the order can just go through as is, since she's here. Okay? All right. Thank you. Thank you. Court does call the case of the People versus Rakesh Sabharwal. Sabharwal?
Echelon of the people.
I probably messed that up, but I did what I could.
Good afternoon, Your Honor. Kenneth Thompson appearing on behalf of Rakesh Sabharwal, who stands to my right. Rakesh, could you say your name for the record?
Rakesh Sabharwal.
That's exactly what I said. All right.
That's what I heard.
Okay, you're requesting an adjournment?
That's correct, Judge. And
all right, how much more time did you need?
a couple of weeks, I believe.
2 weeks? Yeah. All right. Probable cause conference, January 23rd, 2025, 9 a.m. or as your invite indicates.
And Judge, could I address bond briefly?
Sure.
Might be a little premature, but my client has a pre-planned family vacation, a cruise coming up in April. I think this case is going to be over by then, but he has a few days to cancel that to receive his deposit back. I do have.
Where is it to?
He will be traveling to Rome, and the cruise leaves.
I am apparently doing something very wrong. I got Hawaii. I got Rome. I'm going to Southern Pittsfield. I just go ahead. I'm sorry.
And for the judge, you could tailor the order how you like.
That's true. I could.
I mean, but
is there going to be any objection from the people in terms of those dates?
No, Your Honor, I did let defense counsel know that this person may already be on probation by that point, so I don't have an issue with it as a bond condition, but if we get to the place where we're done with the plea and all of these sorts of things, it may need to be addressed with probation, so.
Right.
I just don't want him to give you permission to continue.
Understood. Understood. Yep. So, counsel, if you prepare an order to that effect at this point, and
as a bond,
that might as a bond, and then that way maybe it might be a little bit easier once you get to that point. All right. So at this point, bond continued. Prepare that, and I'll sign off.
Thank you very much, Judge.
All right.
Good to see you, Your Honor.
Good seeing you. Yes. Take care.
Thank you, Your Honor.
Court calls the case of the People versus Matthew Gingras. Gingras?
Yes. We're on Zoom. Good afternoon, Your Honor. Jeffrey Abood appearing on Zoom on behalf of Matthew Gingras, who's also present via Zoom. Also present are attorneys Matthew Tabby and Angela Kaminsky from the Abood Law Firm. I appreciate you allowing us to do this Zoom this afternoon. I'm actually in the Huron County Circuit Court for a trial and stepped out, and that's why my associates are on just in case I wasn't able to step out.
Oh, okay. I thought you just brought troops with you or something. I don't know. I didn't know what was going to happen. Okay. And what are we doing? And your client is here. Could you state your name, please, sir?
Matthew Gingras, Your Honor.
All righty. Thank you. What are we doing today?
Is the prosecutor in the courtroom at all? Is there any way I could talk to him? I believe it was Mr.
There's like a whole herd of them.
All right. Well,
This is Andrew Childers. I'm here on the case, Jeff. How are you?
Oh, you're handling it. Good. How are you?
Good.
Good. Is there any way we can?
Glad we can have a reunion. And by the way, when you just said, I'm glad he's handling it, you just insulted about 5 other prosecutors. But that's okay, counsel.
Who said
Don't
I'm
worry
glad?
about it. When you
I
come
said,
back,
oh.
welcome back.
I said, oh, you're handling it. I didn't say I'm glad he's handling it, but
Okay. Well, I'm just telling you how it was taken. So
may I have a breakout room with Mr. Childers? Or Mr. Childers, can we talk about this on the phone?
First of all, I don't do breakout rooms. I will adjourn it out so you guys can talk in the interim and see what you can work out.
That's great. Thank you. I'd love to.
I will. I'll shoot you a message with my email with my contact, my cell number, and you can give me a call. Okay.
Thank you. And then, Judge, as far as it,
I was going to put it on the 23rd or the 30th, but I only want your associates here. I want a day you're not available. No, I'm kidding. I'm just doing that for the prosecutors.
Well, guess what, Judge? I was going to address I'm not available on either day because the trial I'm in right now in Huron County, those are both return dates. So I was going to ask for a date in early February, if that's okay. I am in this trial through the rest of the month.
Do you have any problem with that? Well, will February 6th work for you, counsel?
I'm going to look, but I'm assuming yes. And if not, we'll make the judge happy and send my associates. So February 6th. Ooh.
13th.
That's third. Okay. February 6th, hopefully we'll all be in New Orleans for the Super Bowl. February 13th.
Oh, no. See,
We'll
that's it. That's it. I got Hawaii, Rome. Somebody's going to New Orleans. That's it. No, not letting anybody go. I'm setting.
We're going to the Super Bowl, Judge.
Okay, we'll go to the Super Bowl. We'll go to the Super Bowl.
But Judge, listen, I do have clients that might be playing in it, so I might have to be there. But February 13th is perfect.
Okay.
And hopefully we reach a resolution sooner, and if we do, we'll let you know. So.
All right. February 13th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right.
Thank you, Judge.
Thank you,
nice to see you. Appreciate it.
Good seeing you too, sir. If somebody else says they're going someplace, that's it.
Meet the good data AI assistant. Think it's just another chatbot? Think again.
No, I don't tell people where I go. Court calls the case, People versus Emma Mathis.
Dr. Lonnie for people.
Good afternoon, Judge Larry Margolis on behalf of Emma Mathis. Ms. Mathis, please state your name.
Emma Mathis.
Thank you, ma'am. All right, what are we doing?
I'm hopeful that we're working toward a resolution. Ms. Londi has advised she would like to speak with the complaining witnesses, the officers, before we have a resolution. So I would defer to Ms. Londi as to the length of time she would like to do that. I'd be requesting the adjournment.
Well, a couple weeks do it, Ms. Londi. Probable cause conference will be adjourned January 23rd, 2024, 25, 9 a.m. Bond will continue. Thank you.
Judge.
Court calls the case, People versus John Lee McHugh.
Lawrence Margolis on behalf of Mr. McHugh, who is present in my office. Please state your name, sir. John McHugh.
All right.
Amy Reiser on behalf of the people.
So
Hey, what are we doing today?
We would like an exam date. The people have graciously provided discovery, and we are prepared to go forward with the exam.
Would you have your witnesses available the 21st?
We could, because he's out of custody, could we have a later date?
28th work?
Yes.
Any objection to the 28th, Mr. Margolis?
I don't believe so, Judge. No.
January 28th, 2025, 9 a.m. That is before Judge Washington.
Thank you.
Bond continue.
Thank you, Judge.
Thank you. Court calls the case, People versus Chloe Whitsett. Excuse me. No, it's the T's are together.
So there's a attorney on behalf of the people?
Your Honor, may I please have 10 minutes, please?
Yes, ma'am. Pardon? I guess. I just gave somebody. Court calls the case, People versus Gracia Cheatham.
Jacob County for the people.
And good afternoon, Your Honor. May it please this honorable court, Rita Young, appearing on behalf of Ms. Cheatham, who is present by Zoom. Ms. Cheatham, could you state your name for the judge, please?
Gracia Cheatham.
Thank you. All right, what are we doing?
Request an exam date, Your Honor.
All this is complete.
Yes.
My understanding that there was an issue with discovery.
There's an issue with discovery. What is it?
CSAM that needs to be showed to the defense counsel. Discovery is not complete.
Well, Judge, I was told that I had to go to the prosecutor's office in order to view a piece of discovery and that I needed to sign a protective order, which I'm willing to do, but I don't want to hold up the exam. So if the court can set it out 2 weeks, I'll make the arrangements to go to the prosecutor's office and review it.
Well, I will adjourn the PCC for a couple weeks and then we can set an exam once I'm sure discovery is all complete.
Very well, Your Honor.
Probable cause conference in this case will be adjourned to January 23rd, 2025, 9 a.m. or as your invite indicates, bond will continue.
Judge, I have 3 other matters scheduled for that morning.
They'll
and
wait.
one matter in the afternoon. No, they won't because they're in Wayne County. So sorry.
Wow. You know, it used to be, Miss Young said I was her favorite.
You are still my favorite.
No, apparently that has changed. That's fine.
Okay.
I got tough skin. I'll make it. Will the 30th be a better date for you, counsel?
Yes, please, Your Honor.
All right, January 30th, 2025, 9 a.m. or as your invite indicates. Bond
Thank
continue.
you. Thank you so very much.
Thank you, Your Honor.
Court calls the case, People versus Charles Tingley.
I am Charles Tingley.
Just to hang on, Mr. Tingley, please.
Yes, sir.
Decker County for the people.
Your Honor, Joe Simon on behalf of Mr. Tingley, and Mr. Tingley, now please state your name for the record.
I am Charles Tingley.
All right, I need a camera, please, also, sir. All right. What are we doing today?
Your Honor, on Tuesday, the court signed the order allowing the release of supplemental discovery that pursuant to that order, I can only review with my client, not send to him. So I'm going to make arrangements to do that. He's up in northern Michigan, not Hawaii, or he's not or anywhere else. But I'm going to make arrangements to do that with him digital or electronically, and I'm asking if the court will therefore adjourn the probable cause conference until that's completed, some 3 weeks-ish.
3 weeks? All right. Any objection from the people?
No objection, Your Honor.
January 30th, 2025, 9 a.m. or adjourned by indicates bond continued. Okay.
Thank you, Your Honor.
Thank you.
Your Honor, may I approach on an unrelated matter?
Yes, sir. Yes. Ready. Here we go. I spend my life ready. You sure?
Yes, sir.
In anticipation about what I'm going to go through right now, this is absolutely all your fault.
Oh.
Already blaming someone else? Classic courtroom move. Set the stage for drama before the real fight begins. Who do you think he's pointing the finger at here?
In anticipation.
In anticipation of it, I'm just letting you know.
Well, let me apologize in anticipation for this being my fault. I am sorry.
Court does call the case of the people versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3.
Notice how he's dissecting the statute word for word? This is actually smart, because if he proves he wasn't lawfully confined, one whole charge could collapse.
Let me see what we got here. Really getting Magoo.
People State of Michigan versus LaDonta Skinner.
Morning, Your Honor. Raymond Cook for the people.
Public Defender Natalie Payton on behalf of Mr. Skinner, who stands to my right. Please say your name for the record, sir.
Doctor. Thank you.
Your Honor, this is the date and time set for preliminary examination. The people are able to proceed.
All right. Ready to go? Let's go.
Just as a preliminary matter, there is an exhibit, People's Proposed Exhibit 1. I've discussed with the defense counsel some cell phone footage from the incident. I believe that that's going to be stipulated to being admitted.
That is correct, Your Honor.
Exhibit 1.
Correct.
For purposes of preliminary examination, Your Honor, yes.
Okay, very good. You may proceed.
Thank you. The people called Brent Bucknam.
Please come forward. Be sworn.
Take a seat, raise your right hand. Do you solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God? State and spell your first and last name for the record, please.
Brent Bucknam, BRENTBUCKNAM.
You may inquire.
Thank you. Good morning, Mr. Bucknam. How are you? Mr. Bucknam, where were you on April 10th of this year in the afternoon hours?
I was in downtown Ypsilanti.
What were you doing in downtown Ypsilanti?
I was transporting packages from my place of employment to the post office.
And where is your place of employment? And you said in Ypsilanti, is that here in Washtenaw County?
Yes.
All right. While you were transporting these packages, what route were you taking?
I was going south, crossing Michigan Avenue on Washington Street.
What, did anything happen out of the ordinary while you were transporting those packages?
I passed the defendant on the right, leaving about 3 to 4 feet of space between us.
And when you say you passed this individual on the right, were you on foot, in your car, on a bike? How are you transporting?
I was on foot.
What about the other individual?
He was on foot.
All right. And do you see that individual in the courtroom today? Can you please point to him and identify him by an article of clothing that he's wearing?
It's the man wearing a green shirt.
Your Honor, if the record may reflect that this witness has identified the defendant.
Without objection, record shall so reflect.
When you passed by the defendant, what were you doing specifically?
I was transporting packages. One hand was holding a bag of packages, and the other hand was pulling a larger package.
And at the time that you passed the defendant, what was he doing?
He was standing on the sidewalk.
Okay. And how much space was between the two of you when you passed by him?
3 to 4 feet.
When you passed by the defendant, did he say anything to you?
He did.
What did he say?
He said, "You should say, 'Excuse me, bitch.'"
What happened after that?
I ignored it.
Were you able to continue walking?
Yes.
How far were you able to continue walking?
10 feet.
What happened after you got to that 10 feet?
He began making statements in an attempt to intimidate me.
And when you say he, are you still referring to the defendant or some other individual? Okay. What sort of statements was he making?
He was saying, "I will put you in a body bag. I run this street. I will shoot you. I will stab you."
How did that make you feel? Did the defendant ever get physical with you?
Yes.
When did that happen?
That happened about 10 feet later, going south of Washington.
So about 20 feet then from where you initially passed the defendant? What did he do that made physical contact with you?
He punched me in the face.
How many times?
Probably about 20.
20 times? And when he first punched you in the face, did you see it coming? Was it from behind? How did that happen?
I saw.
All right. What did you do when you saw that punch coming?
I tried to push him away.
Were you successful in pushing him away?
Yeah, but he got on top of me and began to attack me some more.
When you say he got on top of you, are you on the ground now or are you still standing?
He pushed me down and I was on the ground.
Okay. How long was he on top of you?
10 seconds.
And while the defendant was on top of you, what was he doing?
He was punching me in the face.
Okay. What got the defendant to get off of your body?
I managed to stand up.
So you managed to get yourself up and push him out of the way? Okay. After you were able to stand up, what happened next?
He said, "I will shoot you, I will stab you, I'll take your packages." And he also kicked the larger package that was on the dolly.
Okay. At that time, did he have anything in his hands?
Not that I saw.
Did he ever have anything in his hands?
He did.
What did he have in his hands?
He had a large flat blade mechanic style screwdriver about 10 inches in length.
When did when did the defendant get that screwdriver?
As he was running away towards the Groin property next to the vehicle.
So when did he run away?
After punching me in, after I managed to get up.
Okay, so he gets you on the ground, you get him to get off of you, and then he runs away. Is that what you're saying?
I pushed him to the wall to defend myself, and then he runs away.
Okay. What were you doing as the defendant was running away?
I got my phone out to record
Why did you get your phone out?
because I wanted to have his identity verified.
Had you met the defendant prior to that day? Okay. Were you able to record the defendant? What happened while you were recording the defendant?
He said, "I'll stab you." And he continued to run away.
At any point, did he raise the screwdriver or threaten you with that screwdriver?
He did.
When did that happen?
As he was running away from the beer cooler towards the Roanoke property.
And what did he do exactly with the screwdriver that threatened you?
In his hand while verbalizing, "I'll stab you."
Do you know how far away the defendant was when he made that statement? Okay. When he raised the screwdriver and threatened you with it, what was going through your head?
I was concerned about the stabbing, so I did not pursue it.
So you believed that he would stab you?
Yes.
All right. And after the defendant makes this statement, what happened next?
He continues to run away onto Roanoke's property.
Did you follow the defendant?
Not after he made that statement.
Okay. I'm going to try and hook up, and if I may publish, or going to move to admit what's been marked as People's Pros Exhibit 1. I believe it's been admitted by stipulation at this point.
Exhibit 1, if I haven't said so,
Thank you. May I publish? Just for the record, I put up People's Exhibit 1 just before I start playing this. Sir, do you recognize this still frame?
I do recognize this.
And is this the video that you took depicting what happened that day? All right. I'm going to play People's Exhibit 1. It's a video about 19 seconds long.
Stab you! Stab you!
We can take, perfect, thank you. No further questions, thank you.
Cross-examination.
Thank you, Your Honor. Well, Mr. Bucknam, my name is Natalie Pate. I'm an attorney for Mr. Skinner. I just have some questions to ask you to follow up on your testimony that you given to the court today, if that's okay. If at any time you either don't hear my questions or frankly they don't make sense or just need me to repeat it for whatever reason, let me know and I'm more than happy to do so. So at the time of this incident in April, you were an employee of the Rocket, and that's like a gift toy store, right? And do you still currently work there? And how long have you worked there? 14 years. And you testified that you were on your way to the post office at this time, correct? And I believe you testified that it was like a dolly you had your packages on, right?
I have a larger package on the dog and smaller packages in the right here.
And is this dolly, is this something you like pull, for lack of a better term, with a handle behind you? And how large would you say that cart is?
It's a retractable cart, and when extended, it's about 4 feet high.
Okay, thank you. And so when you were walking with your packages on your way to the post office, you bumped into Mr. Skinner with your cart, correct? At one point, however, he did turn around and tell you something to the effect of, you could have said, "Excuse me," correct?
He did.
And some sort of verbal altercation ensued. And this was right outside of the beer cooler in Ypsilanti, correct?
Patient was inside the tap.
Inside the tap room?
So started outside the Broadhill property and continued outside the tap.
So we obviously all just saw the video that we watched, and you took this on your cell phone, correct? And you'd agree with me that Mr. Skinner is walking away from you in that video, correct?
In the video, yes.
And you'd also agree with me that the video depicts you continuing to follow him while filming, correct?
Correct.
And this video does not depict Mr. Skinner following you?
It does not.
And you would also agree with me that Mr. Skinner, we did see in the video that he did hold up a screwdriver, correct? You'd agree with me that at no point did he walk towards you while having that screwdriver in his hand, correct?
He turned around but did not walk towards me.
Thank you. So just a couple other questions, Mr. Bucknam. I may have missed it when you were testifying about how the screwdriver came into play, and maybe honestly, I'm just a little bit confused. So how I understand it, there was a verbal altercation and then some sort of tussle. Where did the screwdriver come from?
He must have had it on his person.
Did you see it at any time before this altercation? And during the verbal altercation in this mutual tussle, did he at any point take out the screwdriver if he had it on him? So you testified today that Mr. Skinner threatened you or threatened to shoot you. Did you at all any time see him with a gun? When he made these verbal threats, did he present any sort of weapon? Did he present any sort of object at all when he made these threats? Did he even have anything in his hands? Thank you, Your Honor. No further questions for this witness.
Any redirect?
No, Your Honor, thank you.
All right, thank you. Sir, you may step down.
Your Honor, the people have no further witnesses and would rest at this time.
Any witnesses for the defense?
No, Your Honor.
Do you have a motion?
Your Honor, the people would move for bind over on count 1, felonious assault with count 2 to follow. I believe the evidence the court heard was that the victim was walking down the street just doing his job. When he passed by the defendant became agitated at him and then proceeded to punch him. I believe the testimony was about 20 times, getting the victim on the ground. While the defendant was fleeing from that assault, the victim recorded him, and the defendant, as the court saw, raised a screwdriver at him and said, "I'm going to stab you." He raised it in a threatening manner. Believe that the evidence shows by a probable cause standard that an assault occurred where the victim did state that he was afraid.
Well, why would that be an assault on this individual? Why, I'm talking specifically about the felonious assault.
Because the screwdriver, I believe, is a deadly weapon that satisfies that element, as opposed to why it's an assault. That's because he raised it, threatens him. I believe the victim testified that he was afraid that he was going to get stabbed, and he said as much, and that's why he stopped following him. So I believe that shows that he had that apprehension of an immediate battery.
I get that, but at the same time, the physical altercation which occurred on the ground with the 20 punches to the face, that has transpired. As I understand the witness, they then testified that that attack is over.
Correct.
The defendant, according to the testimony of the witness, then is leaving the scene.
Yes.
The witness then follows that.
Correct.
And is in essence saying, "Leave me alone."
The defendant is making a statement, yes, I want to.
Yeah, and says what he's going to then do.
Yes.
So at that point, why is that an assault? Why he is retreating from, assuming given the testimony heard, a bad act has occurred. He is then leaving from that bad act.
Yes.
He's then followed by Mr. Bucknam.
Yes.
And then turns, and that's when he says something.
Yes, and the people's argument is when he makes that turn.
Go ahead.
When he makes that turn and makes that statement, I believe the video showed him raise his arm and lift the screwdriver in a threatening manner. And given that motion and the victim's statement that he stopped following because.
But why would that be an assault by him?
Because he's making the victim fear an immediate battery.
But only because Mr. Bucknam is following.
Yeah.
That's the only reason. The only reason that portion of the altercation occurs is because Mr. Buckman goes after him.
Yes, and I believe the victim testified the reason he was recording was in order to get the defendant's identity due to that assault. He was trying to make sure that this could be responded to. I don't believe that following a defendant gives that defendant the right to then threaten that individual with a screwdriver, especially in an area that's open to the public and there's no reasonable expectation of privacy.
I don't know where the privacy issue comes in, but okay, all right. Response.
Your Honor, I would object to the bind over on the count of assault with a dangerous weapon. I would argue, Your Honor, that there was no assault with a dangerous weapon or the screwdriver. The complaining witness did testify that Mr. Skinner at no time stepped towards him while the screwdriver was in his hand. Obviously, we all saw the video and that Mr. Skinner did raise his hand up while holding a screwdriver while he was being followed. He made no movement and did not put the complaining witness in a position of a reasonable fear of a battery. Given the nature of the weapon also being a screwdriver, to be candid, it's not a gun. Without any movement towards the complainant, my client would not have been able to assault him with a dangerous weapon. That being said, Your Honor, I would object to the bind over, and I do believe even by a problem.
Well, he wouldn't have to necessarily make a movement. He would just have to have the ability to come into contact. Which if he had run in the direction that the camera was pointing, he could have done that.
Absolutely, Your Honor. If he had run that way or chose to flail that object in his direction. But of course, that's not the situation we have here. Mr. Skinner, there was some sort of fight. I won't dig into that. Mr. Skinner was walking away from it. He had an object in his hand. He was being followed. He turned around and told the complainant whatever he said. And I would argue that the people did not meet their burden even by a probable cause standard and object to the bind over on this felony charge, Your Honor.
Anything additional from the people?
No, Your Honor.
In this case, the court listening to testimony of Mr. Button, and I think it's important to face the court's distinction as to what transpired based upon the testimony of Mr. Button. There was first this assault, which occurs where he's indicating that he's punched 20 times. At some point, he's on the ground, but he then gets himself up, and the defendant is up at that point in time. The defendant, strangely enough, begins, and I'll call it a retreat. He basically begins to retreat. It is then Mr. Bucknam that is continuing. He may have his justification for what he's doing, but he's continuing the potential altercation as he's following it. It is at that point, and remember Mr. Buckman's testimony is that he doesn't see the screwdriver. The screwdriver, he's only presuming that it's on his person. Don't know that, but he's presuming it's on his person at the time of the initial assault. But the defendant is leaving. He's following for the purposes of identification. The threat, there is no longer a threat to Mr. Buckman, other than the one that he is then creating. The defendant turns around, says what he's going to say, raises the weapon. Because of that time frame, the defendant, while he may not have acted right, at the moment that is happening, he is not acting unlawfully in what he's doing and would be entitled to be there and potentially defend himself from what may be an oncoming assault of Mr. Buckman. Maybe, I don't know. So for those reasons, and the court looking at these as two very distinct acts, as I listen to the testimony of Mr. Buckman, the court is going to decline to bind over the defendant on the assault with the dangerous weapon, finding that at the moment that weapon is exposed, it's not an assault with a dangerous weapon. It could be a number of different things, but it's not an assault with a dangerous weapon. And we'll remand it on the aggravated assault to 14A2.
Thank you, Your Honor.
I will set pretrial on count 2.
October
I'm sorry, September 24th.
September 24th, 2025, 10 a.m.
Yes.
10 a.m. before Judge Barth. Found with
Oh, there we are. There we are. Okay. So that's it for today, everybody. That was Judge J. Cedric Simpson. Tomorrow is Wednesday. That'd be Judge Stephanie Boyd, and I like this judge too. To all the new subscribers to this channel, welcome, welcome, welcome. Welcome to the platform. If you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to this channel and helping this channel grow and help supporting the platform. That's it for today. I will see you again tomorrow at 3 o'clock p.m. for Judge Stephanie Boyd. You all have a wonderful evening. Ta-ta and ciao-ciao. And I'll see you again soon. Have a good one.
Never give up on this heart of mine. Put it back together every single time.